So we're going to look at Chapter 18, Performance and Remedies. This is the last of the new material about the general formation and enforcement of contracts. We will continue discussing specific topics in contracts in the chapters that remain, but this is the last of wrapping up the general formation and enforcement of contracts. We'll do a lot of talking about the specifics of sales contracts, warranties, things such as that. So let's look at performance and remedies. Contracts are defined as legally enforceable agreements. If an agreement meets all the requirements, it is a contract and it is enforceable. In most contract situations, the issue of enforceability does not arise because the parties perform their duties fully and voluntarily. The contract is done, it's executed. So there's no enforceability issues. You put your money in the machine, it gave you the drink, that's the beginning and the end. If a dispute arises, questions may be raised regarding the parties' duties of performance under the contract. Conditions in the contract may exist that affect the parties' duties. If conditions in the contract exist, it has to be determined if they have been met. In situations where performance has been rendered, it has to be determined if the contractual duties have been satisfied, or is the performance so defective that it amounts to a material breach of the contract. If a party has failed to perform satisfactorily, it has to be determined if a legal excuse exists for not performing, or whether the duty has been discharged. Even if it is clear that a party has breached the contract in a material way, a dispute still may arise as to the remedies to which the other party is entitled. The rights of the parties have to be determined. So let's look at some conditions. Generally, a party's contractual duty to perform arises when the contract is formed, even though the time for performing is set for a future date. The parties may provide that one party's duty to perform is qualified by the occurrence of a particular event, a condition. So if an event must occur before a party's duty to perform arises, this is termed a condition precedent. Something must occur first. So Theo promises to buy Melinda's racehorse for $100,000 if it wins the Idaho Derby. The horse winning the race is a condition precedent to Theo's duty to purchase. If the horse does not win, a failure of condition has occurred, and Theo has no duty to purchase the horse. It makes sense. The condition is, if the horse wins the race, I will buy the horse from you for $100,000. If the horse doesn't win the race, I'm not going to be interested. If the occurrence of a condition discharges an existing duty to perform, this is termed a condition subsequent. So Jeannie and Malik enter into a contract requiring Jeannie to trim Malik's hedges the day before his garden party, unless it is windy. If it is windy, Jeannie does not have to trim the hedges, and Malik's duty to pay Jeannie is discharged. So understand this, even though I'm throwing about technical terms, we understand the effect in a world we live in. If the contract calls for the parties to perform their duties at the same time, each party's duty to perform is conditioned on the other party's performance. When you do this, I'll do this. Okay, but when you do this, you'll do that, right? So you're going to do it at the same time. This situation is termed concurrent conditions. Neither party can enforce the party's promise without himself tendering performance. So Percy agrees to buy Willa's hardware store for $600,000. Percy does not have a duty to pay the $600,000 unless Willa tends the store. Willa does not have a duty to give Percy the store unless Percy tenders the $600,000. So we're going to do it at the same time. Here's your cash, here's your deed. Hey, that's great, thanks. All right, there's an example case. I believe you can read it on your own. I'm going to ask you to read it on your own because it has some important information in there. And I believe there is a quiz question attached to knowing the information that is in there. Let's take a look at 18.3, the creation of conditions. So conditions can be created expressly or impliedly. Express conditions are created by verbal or written statements in the contract. No special wording is necessary to create an express condition, but they often are created by words such as provided that, on condition that, if, when, while, after, as soon as. Aren't you glad that you took those adverbial phrases and you had to do a Kellogg-Reed diagram so that you understood? I don't think I've ever been pulled into an alley in my life and asked to do a Kellogg-Reed diagramming of the sentence. I just know how to use language. The nature of the parties' contract also may lead the courts to imply a constructive condition or an implied condition on the parties' duty of performance. So let's look at the example. In bilateral contracts that call for an exchange of performances at the same dates, or that do not state a time for performance, the law infers that each party's performance is a constructive, concurrent condition of the other party's duty to perform. In a contract between Shane and Joyce for the sale of a motor scooter, there it is, Shane's duty to pay for the motor scooter is conditioned on Joyce's delivery of the motor scooter. And Joyce's duty to deliver is conditioned on Shane's tender of the purchase price. If the contract calls for Joyce to deliver the motor scooter on March 1st and Shane to pay for it 2 weeks later on March 15th, Joyce's delivery would be a constructive condition precedent of Shane's duty to pay. Let's take a quick question, answer, comments. Let's look at standards of performance. A common dispute between parties to a contract is whether each has fulfilled its duty of performance under the agreement. Promisors must perform their contractual duties in the manner they have promised to perform them. If they do not, they are liable for breach of contract. They are not entitled to payment under the contract, and the contract can be terminated. Courts have attempted to create practical standards for evaluating the parties' performance. So 3 basic degrees of performance are recognized: complete performance or satisfactory performance, substantial performance, and material breach of contract. So it is important to know the difference. So let's look at complete performance or satisfactory performance. Some types of contractual duties can be performed completely and perfectly. The payment of money, the delivery of a deed, and the delivery of certain goods, each are duties that can be performed to a high degree of perfection. Promisors who perform completely such duties are entitled to receive the full contract price in return. Promisors in complete performance contracts who do not perform completely cannot recover the contract price. They may recover in quasi-contract for benefits conferred on the other party. So when you have complete performance or satisfactory performance, it's very easy to see when compliance has been met. Substantial performance is different. Some types of contractual duties are difficult to perform perfectly because of their nature and the limits of human ability. So we have agricultural projects, construction projects, contracts for personal or professional services. In most cases, these duties are capable of being performed substantially. Substantial performance is performance that falls short of complete performance in minor respects, but does not deprive the promisee of a material part of the consideration that was bargained for. So no matter how well Metallica plays, they could have done it a little better. But there will be circumstances where you're going to say, that was pretty good. When it comes to constructing something, you could always have constructed it better. There will always be minor flaws. The question you have to ask is, did you get substantial performance? So in most cases, these duties are capable of being performed substantially. Substantial performance is performance that falls short of complete performance in minor respects, but does not deprive the promisee of a material product consideration that was bargained for. Promisors may make a genuine attempt to perform, but due to lack of ability or factors beyond their control, they fall short of complete performance. If their performance is such that it cannot be returned to them, and there was no express condition for complete performance, the party will be held to have performed substantially their duties. This allows the promisor to be compensated for her performance. So a building that deviates slightly from the contract specifications. Trust me when I say it. Even if the architect has drawn perfect plans, there will be deviations from the contract specifications. Things happen. What constitutes substantial performance depends on the circumstances of each situation. The promisor who performs substantially generally is entitled to the contract price, less any damage the other party has suffered as a result of the defective performance. If the promisor willfully failed to perform completely, the doctrine of substantial performance will not apply. So what is a material breach? The promisor is liable for material breach of contract if her performance fails to reach the degree of perfection the other party is justified in expecting under the circumstances. Such a promisor has no right of action under the contract and is liable to the other party for damages resulting from the breach. If the promisor's defective performance conveyed some benefit to the other party that cannot be returned, the promisor may be able to cover under quasi-contract the reasonable value of benefits conferred to the other party. So there's another example case here. I'm going to ask you to read that on your own. It has some important information and important concepts in there. I'm going to trust that you will read it. Again, I know that on one of these cases, and I don't remember which, there's important information, and I do ask a question on the quiz. So make sure you're reading these cases. Let's see if you have any comments or questions before we move on to anticipatory repudiation or anticipatory breach. You know, every once in a while, I get impressed with my ability to roll some of these things off my tongue, such as anticipatory repudiation. I mean, that's kind of a fun thing to say. I wouldn't want to say it 3 times quickly. Then again, you've probably noticed that I have trouble with the word materiality. So I'll just say in a material way. And you've probably caught that. Oh, well, you know, I'm substantially performing. I'm doing the best I can. I think I'm doing pretty well for a man who had a stroke several years ago. All right. Now on to anticipatory repudiation. A promisor also may be held to have breached the contract under the doctrine of anticipatory repudiation or anticipatory breach. If the promisor, prior to the time for performance, indicates an intent not to perform her duties under the contract, the other party may treat the contract as breached and sue for that breach immediately. Anticipatory repudiation may take the form of an express statement by the promisor, or it may be implied from the actions by the promisor that indicate an intent not to perform. So Justin has contracted to sell his boat to Basel. But 2 weeks before the delivery date, Justin sells the boat to Marcia. Justin has repudiated his contract with Basel. You can see it a mile away, right? You're not going to expect that this boat gets delivered. He just sold it off. Marcia, Marcia, Marcia. All right, let's look at special performance problems. Two special problems related to performance need discussion in detail. Contracts where the promisor agrees to perform to the personal satisfaction of the promisee, and construction contracts that condition the property owner's duty to pay the builder upon obtaining an architect's certificate or an engineer's certificate certifying that the builder performed satisfactorily. So I want you to listen up. I'm going to give you some advice. You really need to take this advice. When a promisor agrees to perform to the promisee's personal satisfaction in contracts involving personal taste, personal comfort, or personal judgment, the promisee who is honestly dissatisfied may reject the performance without liability, even if doing so is unreasonable. So, allow me to make this statement. If you make a contract that is to be performed to the personal satisfaction of the other person, if the other person is not happy, that is the only gauge of figuring out if it's been breached. You do not take a poll and say, well, this person and this person and this person and this person say that this is fine. It doesn't matter. So my advice, avoid, do not make contracts to the personal satisfaction of the other person. So I'll tell you two stories. First, you never need pay for a meal at Taco Bell ever again. Here's the trick. You will notice that at Taco Bell's, they have a sign that says, if you are dissatisfied with your meal for any reason, they will cheerfully either remake the meal or refund your money. So do you see the loophole there? You never need pay for a meal at Taco Bell again. It had too much meat, not enough meat. It had one speck too much. Their sign says, for any reason, if you're dissatisfied. So you just go right back up to the counter and you say, hey, my family of 18 enjoyed their whole meal, but there was one piece of lettuce too much. We'd like all our money back. You do see that I'm being sarcastic, but I am pointing something out. According to their sign, if you're not satisfied, they'll either remake it or give you your money back. So, Embassy Suites. This was about 25 years ago. I was dating someone else at the time. So, Embassy Suites at the time was $99 a night. It was a suite. So, we rented the suite. Next morning, I go down and I say, I'm not paying for the room, because they had a sign, if you're not satisfied, you don't pay. And they said, what was wrong with the room? And I said, it's a suite. I paid $99 for this. And you have a freeze or fry shower head. I spent my whole time either freezing or frying because your water doesn't moderate itself. And the person behind the counter looked at me and said, well, that seems like a minor thing. And I said, I don't know, it's a suite. You have a sign that says if I'm dissatisfied, I don't pay. It seems to me that a person should not have to render themselves to a clinic because they've either been frozen or burned by your shower head. Again, my advice, avoid contracts that are done to the personal satisfaction of the other party. I absolutely know there is a question on the quiz about this. I believe I have provided you adequate information to understand it does not matter how many other people say, seems okay to me. The only person that it matters is that other person. If the contract involves mechanical fitness, utility, or marketability, most courts require the promisee to accept performance that would satisfy a reasonable person. Building and construction contracts commonly require the builder to give the owner a certificate issued by a specific architect or engineer before the owner has a duty to pay the builder. These certificates often are issued at each stage of completion, indicating that the work is done to the satisfaction of the architect or engineer. Contractors who are unable to secure and produce a required certificate cannot recover under the contract unless the failure is excused. This can be done by showing the architect or engineer is dead, ill, or insane. They couldn't render performance if they wanted to. The architect or engineer is acting in bad faith, or the other party has prevented the issuance of the certificate. Understand that if you are an architect or an engineer and you issue these certificates, your reputation goes along with you. If you are awkward about it, then you're not going to get hired to issue these certificates. Now, if you decline to issue a certificate in good faith and your reputation supports that you have good reason, you can issue the denial, right? Or you can deny their certificate. So again, the idea is that you act in good faith.
So are these certificates mostly for like commercial use of buildings, or like if someone was going to build or manufacture a home, would they do the same thing with you?
So it's mostly for commercial buildings. There's nothing that says you couldn't write a contract that had this in your personal home if you wanted it. I mean, that would be unusual, but you could do it. Understand that getting this certificate issued is going to cost. You're going to have to hire. But if it matters, if you're building yourself a $30 million mansion, yeah, you may want to have an engineer or an architect certificate. But yeah, if you're just building yourself a $125,000 home, I don't know if you necessarily want that expense.
Okay, I just wondered because I've been looking at modular homes and I know that they build them in parts, mostly like in the factory, but then they place them and stuff. And there's different steps that they have, unlike a traditional home, because the house literally changes hands and location. So I wasn't sure if something similar would apply to that.
The honest truth is, I don't know enough to give you an educated answer on that.
Okay, thank you.
You're welcome. So if the architect or engineer who denies certification is acting in good faith, even if she is unreasonable in doing so, most courts hold the owner has no duty to pay under the contract. A minority of courts recognize unreasonable refusal as an excuse where the contract has been substantially performed. Understand, in a market economy, if you are unreasonable, your reputation will precede you and you're not going to have a lot of business. You're going to want to have a good reputation. What's the time for performance? Failure to perform on time is a breach of the contract. In some cases, the failure may be serious enough to constitute a material breach. If the contract does not state a time for performance expressly or impliedly, performance must be completed within a reasonable time. What constitutes a reasonable time depends on the circumstances. So I'm going to give you a state of art term. You may want to use this in contracts where it matters. Here we go. In time is of the essence contracts, failure to perform on time is a material breach. A contract expressly may provide that time is of the essence. There, you have the phrase. If you have a contract where time is of the essence, again, you are master of your agreement. You're going to want to express to the other party, time is of the essence. You're going to want to write it into the contract. Again, the idea is this. If it matters to you, you should say something. The other party should know it matters to you. When we go into other topics, you can see that you're going to want to make sure the other party knew it mattered to you. Because courts are going to say, did you let them know it mattered to you? Well, great. Now they knew what they were agreeing to. So in time is of the essence contracts, failure to perform on time is a material breach. A contract expressly may provide that time is of the essence. Courts will enforce the provision unless doing so would impose an unjust penalty on the promisor. Courts may imply time is of the essence if late performance is of little or no value to the promisee. TAD contracts with the local TV station to run a series of commercials for frozen turkeys the week leading into Thanksgiving. But the TV station does not run the ads until the day of Thanksgiving. Time is of the essence is implied in this contract, and the TV station has breached. It's a material breach. I think we all can see this and agree. Those ads are of little value on the day of Thanksgiving or after. If time is not of the essence in a contract, the promisee must accept late performance that is rendered within a reasonable time of when performance was due. The promisee then is entitled to deduct or set off from the contract price any losses suffered because of delay. So, if it matters to you, if time is of the essence, express that to the other party, write it into the contract, make sure there are no surprises. Because the honest truth is, if time is of the essence, you're going to want whatever that performance is in a timely manner because you don't want to take the hit. So make sure they know. Comments or questions before we move on to excuses for non-performance? So promisors who fail to perform satisfactorily may be able to avoid liability for breach of contract if they can demonstrate some legal excuse for their failure. Prevention of performance and impossibility of performance are two traditionally accepted forms of excuse. Let's look at prevention. Under prevention of performance, a promisee who causes the promisor's failure of performance cannot complain about the failure. Promisees owe promisors a duty of cooperation in the performance of the contract. Promisees who breach this duty by failing to cooperate or actively hindering or delaying performance are themselves liable for a material breach of the contract. This relieves the promisor of any duty of further performance under the contract. Again, you must act in good faith. Top of 18.8. If it becomes impossible for a promisor to perform her contractual duties, the duty of performance is discharged and the promisor is not liable for material breach. Impossibility in the legal sense means it cannot be done, not I cannot do it. I would highlight that. Pay attention. Impossibility means it cannot be done. Impossibility does not mean I cannot do it. Promisors who find they have agreed to perform duties that are beyond their capabilities or that have become unprofitable or difficult to perform generally are not excused from their duty to perform. If an event arises after the formation of the contract that renders performance objectively impossible, non-performance will be excused. So let's look at some of these. Illness or death of the promisor. Personal service contracts are the only agreements where the death of the promisor terminates the contract. Damon contracts to sell his house to Troy, and he dies before the closing date. Troy can enforce the contract against the estate because the subject matter of the contract is not a service. The transfer of real estate satisfies the terms of the contract. What did you contract for? Piece of real estate. Person dies, that's fine. You can still hand over the real estate and I'll still give the money for that real estate. Now, Damon is a musician and he dies before giving a concert he has agreed to perform. The estate is not liable for breach of contract because the subject matter of the agreement is a personal service. Substituting another musician does not satisfy the terms of the contract. Again, it's impossible to perform. Now, somebody out there is going to say, yeah, but I've seen Weekend at Bernie's. We might be able to pull this off. That would be fantastic. Go ahead, make a movie, but you get the point. A dead musician is worth nothing up on stage. Illness may excuse the promisor's failure to perform if the nature of the required performance and the seriousness and duration of the illness make it impossible for the promisor to substantially perform. So that's one example of impossibility. Next example, intervening illegality. If a regulation or statute enacted after the creation of the contract makes the performance of a party's contractual duties illegal, the promisor is excused from performing. Regulations and statutes that make performance more difficult or less profitable do not excuse non-performance. Makes sense. Next example, next situation. Destruction of the subject matter. If something that is essential to the promisor's performance is destroyed through no fault of her own, the promisor is excused from performing. Jenna is hired to give a martial arts demonstration at the local health club. If the facility is leveled by a tornado prior to the date of performance, her non-performance is excused. The destruction of items the promisor intended to use in her performance does not excuse her non-performance if substitute items are available, even though obtaining them makes the performance more difficult or less profitable. So, if the musician loses, breaks, no longer has the guitar, go get a substitute guitar. Get up on stage with a substitute guitar. Commercial impracticability. Next one. Some courts relax the strict common law position on impossibility of performance by recognizing an excuse for non-performance where circumstances that do not amount to impossibility. So these courts recognize commercial impracticability as an excuse where unforeseen developments make performance highly expensive or unreasonably expensive or of little value to the promisee. So our example, Berwick rented a tractor from GrowCo. The contract requires GrowCo to keep the tractor in repair. While Berwick has the tractor parked, it is rammed by another tractor, causing severe damage. Estimates indicate that it will cost more to fix the tractor compared to its value prior to the incident. A court likely will find it is unreasonable under these circumstances for GrowCo to repair the tractor. It will be written off. It will be totaled out. It will be paid off. Again, that's why insurance companies, for example, they will total the car out. If it's going to cost more to fix it than the car is valued at, they'll just total it out and move on. Commercial impracticability acts as an excuse only if the promisor expressly or impliedly did not assume the risk that the event would occur. The Restatement of Contracts has adopted the commercial impracticability standard, as has the UCC for contracts involving the sale of goods. Again, if the value is less, then just pay it off. Commercial frustration. Again, still looking at impossibility. Commercial frustration or frustration of venture is similar to impracticability. Under this doctrine, performance is excused when events occur after the formation of the contract that would make the reciprocal performance of the other party worthless to the promisor. Like impracticability, the event must not have been foreseen, and the promisor must not have assumed the risk expressly or impliedly that the event would occur. So we'll take a look at this case. An employee had a one-year written employment contract. Before the year was out, the employer told the employee her contract was terminated because of lack of funding. There is nothing in the contract making her employment contingent on funding. The employee sued for breach of contract. The employer defended under impossibility. The court held that the employer could not rely on the doctrine of impossibility, explaining that performance may be excused if, one, there was an unexpected occurrence of an intervening act, two, the risk of the unexpected occurrence was not allocated by the agreement or custom, and three, the occurrence makes performance objectively impossible or highly impractical. A party's financial inability to perform rarely excuses performance. Insolvency is unlikely to excuse performance because a party generally assumes the risk of its own inability to perform. Parties may reallocate risk by agreement within the contract, but in this case, they did not. Again, if you are master of your agreement and it matters to you, write it in. Comments or questions before we move on to discharge? So what is the nature of discharge? Parties who have been released from their obligations under a contract are said to be discharged. Normally, both parties to a contract are discharged when they have performed their duties completely. There are several other circumstances that operate to discharge a party's duty of performance. So you can discharge by agreement. Since contracts are created by mutual agreement, they also may be discharged by mutual agreement. An agreement to discharge must be supported by consideration to be enforceable. The consideration could be as simple as, we just don't want to do this anymore. That has value. That's consideration. Discharge by waiver. A party to a contract may waive his rights to insist on complete performance. Waiver occurs when a party accepts incomplete performance without objection, knowing that the defects in performance will not be remedied. To avoid waiving their rights, parties who receive incomplete performance should give the other party prompt notice that they expect complete performance and will seek damages if the defective performance is not corrected. Again, if it matters to you, say something. So I've had people ask, can you give me a discharge by waiver? I tell my son that he may not go out on his date until he has mowed both the front yard and the backyard. And my son mows just the front yard and he says, Dad, please, can I go on the date? And I say, okay, that's fine. You did the front yard. You don't have to do the backyard. You can go on the date. That's an example of a discharge by waiver. Discharge by alteration. If the party's agreement is represented by a written instrument, a material intentional alteration of the instrument by a party discharges the other party. If a party consents to an alteration or does not object to it after learning of it, he is not discharged. Alterations by third parties without the knowledge or consent of either contracting party does not affect the party's rights. Again, you must come to the contract with clean hands. You go altering things in there, then the courts are going to say, hey, we're going to discharge this contract. You don't have clean hands. Discharge by statute of limitation. Courts long have refused to allow a party to sue if they delay an unreasonable time in bringing their lawsuit. All states establish by statutes the reasonable time within which a lawsuit must be brought. These time limits are termed statute of limitations. Again, if you have a claim, if you have a gripe, if there is a problem, speak now or forever hold your peace. A party who has breached a contractual duty may be discharged from liability for breach if the other party does not bring a lawsuit within the statute of limitations. The time period for enforcing contracts varies from state to state, and many states distinguish between verbal and written contracts. Here's a fact. You'll want to highlight it. It likely will be on the quiz in some shape or form. Here we go. The UCC statute of limitations for contracts involving the sale of goods is 4 years from the time the goods are tendered. The statutory period ordinarily begins to run from the date of the breach, but it may be delayed if the party with the right to sue is incapacitated, such as insanity. So what's the fact? 4 years from the date of the breach. Bring that lawsuit within that 4 years if it is for the sale of goods. Likely to be on the quiz. Comments, questions before we move on to remedies? What is the theory of remedies? If a party does not perform as promised under the contract and performance has not been discharged or excused, the other party is entitled to a remedy for the breach. A court that awards a remedy for breach of contract attempts to place the injured party in the same position she would have been in had the contract been performed. Take your highlighter, highlight this. This is a fact to know. What is the court going to try to do? So, one more time. A court that awards a remedy for breach of contract attempts to place the injured party in the same position she would have been in had the contract been performed. Typically, this is done by awarding the injured party a judgment for money damages. If the liable party does not pay the judgment, the successful plaintiff is entitled to the court's assistance in enforcing the judgment. So, damages in contract cases. Several types of damages may be recovered in contract cases. What may be recovered depends on the circumstances of the case and must be proved with reasonable certainty. Losses that are speculative are not recoverable. You have to be able to state what your damages are, what are your losses. You don't get to speculate. So you can read the case about DuPont Flooring and Discovery Zone on your own. Let's look at compensatory damages on 1812. A party suing for breach of contract who has suffered actual losses as a result of the breach is entitled to recover compensatory damages. These damages are designed to place the plaintiff in the same position as if the contract had been performed, just as I said. Compensatory damages ordinarily are measured by the loss in value of the promised performance. This is the difference between the value of the performance the plaintiff actually received and the value of the performance she had a right to expect. If no performance is rendered, the damages would be the value of the promised performance. The court will subtract from the damages any cost or loss the plaintiff was able to avoid by not having to perform her own contractual promises. So we have this example. Derwin agrees to sell his accordion worth $300 to Juniper for $250, but he later backs out of the agreement. Juniper's loss in value would be $300 less the $250 she did not pay Derwin, so her damages are $50. Compensatory damages normally are limited to losses that ordinarily occur as a result of breaching the contract. So those are compensatory damages. Let's look at consequential damages. So in some cases, the special circumstances of the plaintiff cause her to suffer losses that ordinarily would not be foreseeable as a result of the breach. Normally, such consequential damages are not recoverable unless the defendant had reason to foresee them at the time the contract was created. Generally, this means the defendant must have known the special circumstances that caused the loss. So, if Swifty Trucking contracts to deliver parts to Pinnacle Manufacturing without knowing that the Pinnacle plant is shut down, waiting for the parts, Swifty is not liable for the consequential damages that Pinnacle suffered as a result of Swifty's late delivery of the parts. So let's do a callback. In this example, what would Pinnacle want in their contract so that Swifty knew how important these parts were?
They would want trying to remember what I called it, but the clause about it being expedient or
Who can help?
hold on. I have it in my notes. I just
Time is of the essence.
Bingo.
Yeah.
If it matters, then you're going to want to put a time is of the essence clause. Trust me, if your plant is shut down awaiting these parts, when you made that contract, you're going to want to be very insistent. Can you get these parts to us? Right? Time is of the essence. If you don't get these parts to us, we're shut down. Can you perform? Fabulous. You do understand that if you don't perform, we're out.
thank you.
Okay? Top of 1813. Let's look at nominal damages. Nominal damages are small amounts that the courts award the plaintiff when the technical breach of a contract has occurred without causing any actual loss. So typical nominal damages are $1. In the case of nominal damages, they say, yep, there was a breach of the contract, you've been wronged, but have $1. Liquidated damages. These are important. Let's take a moment. If the parties to a contract may determine in advance that a specific sum can be recovered if the contract is breached, these provisions are termed liquidated damages. If the amount specified is reasonable, and if the nature of the contract makes actual damages difficult to determine, liquidated damage provisions are enforced. And again, there's a callback to Chapter 12, page 8 on due and certain debts. When liquidated damage provisions are enforced, the amount of damages agreed on is the injured party's exclusive remedy. If the amount specified is unreasonably large compared to the probable injury or loss, or if the amount of the damages easily could be determined in the event of breach, the court declares the provision to be a penalty and refuses to enforce it. I'm going to read this case to you. I know there is a question about this on the quiz. I don't want to hear any griping from anyone about it. I'm telling you, this court case has a question on the quiz that is an analog, that is similar, where I would expect you to read this information and be able to apply it to a question on the quiz. So if you haven't put a big old star or arrow or Adam said, pay attention, that's on you. Here we go. So this is American Car Rental versus the commissioner. The top of the rental cars agreement stated vehicles driven in excess of 79 miles per hour will be charged $150 per occurrence. All our vehicles are GPS equipped. Customers were charged a $150 speeding fee every time the GPS showed the car's speed exceeded 79 miles per hour for 2 or more minutes. When the rental car company was sued, it defended by arguing the fee was a liquidated damages charge. The court held the fee was a penalty, explaining that the prime purpose of the penalty under a contract is preventing the breach of the contract by holding over the head of the contracting party the threat of punishment for a breach. A provision for liquidated damages is designed to determine fair compensation to the injured party when the contract is breached. In this case, the fee was 400 times more than the possible increased wear on the car caused by the speed. The fee is not reasonable. It is a penalty. Look for such a question on the quiz. You are on notice. Let's look at punitive damages. Typically, punitive damages are not recoverable for breach of contract. They are recoverable only when extreme circumstances justify penalizing the defendant, such as if the breach of contract is malicious, willful, or wanton. Punitive damages also sometimes are specifically authorized by statute, such as consumer protection regulations. While punitive damages ordinarily are not available in contract cases, they are available if the plaintiff can sue in tort for a bad faith breach. In these cases, a plaintiff not only can collect damages for injuries, such as emotional distress, but also are likely to receive significant punitive damage awards because the defendant's actions have been especially wrongful. Bad faith breach of contract actions have been allowed most commonly in suits against insurers for bad faith non-payment of legitimate claims and against employers for wrongful firing of employees. These suits blur the line between contract law and tort, so courts are cautious in applying the bad faith doctrine, but more commonly are allowing the application. So we're going to take a segue here. We're going to talk about the duty to mitigate damages. A party in good faith has a duty to mitigate damages, to lessen their damages. If a breach is occurring and you're incurring damages, you have a duty to mitigate or to lessen the effect of those damages. That is a responsibility in good faith. So plaintiffs who have been injured by a breach of contract have a duty to mitigate the damages they suffer, if they can do so without undue expense, humiliation, or risk. Injured parties are not able to recover damages they easily could have avoided or minimized. So, for example, an employee who had been fired wrongly would be entitled to damages equal to her wages for the remainder of the employment period, but the employee has a duty to make reasonable efforts to seek a similar job and minimize damages. I want you to also read the Blue Hawaiian Adventures case. Again, has important information in there, okay? Let's look at the top of 1815, equitable remedies. So legal remedies for breach of contract usually are money. If the legal remedies are not adequate to remedy fully a party's injuries, a court has the discretion to grant an equitable remedy. What would be fair? Courts grant an equitable remedy only when justice is served by doing so. The two most common equitable remedies are specific performance and injunction. They're in bold, they are vocabulary. I will want you to know what they mean. Specific performance. So if the subject matter of a contract is so unique that a money damage award will not compensate adequately a buyer whose seller has refused to perform, a court may order the seller to specifically perform the contract. Real estate traditionally has been treated as unique and is the most common subject of specific performance decrees. We have this example. Fabrice enters into a contract to sell his house to Dahlia for $200,000. When he learns that the market value of the house is $250,000, Fabrice decides not to go through with the sale. Dahlia sues Fabrice for breach of contract. Her normal legal remedy would be her lost profit on the sale, which would be $50,000. That's the market price less the contract price. Because real estate generally is treated as unique, real estate is not fungible. You can't substitute one piece of real estate for another. Dahlia could get the court to order Fabrice to specifically perform his duties under the contract, which is the sale of the house to Dahlia. Now, personal property generally is not considered unique, but antiques, heirlooms, and works of art may merit the application of specific performance. Again, These are one-of-a-kind things, antiques, heirlooms, works of art. Specific performance generally is not applied in personal service contracts because it would require a form of involuntary servitude under the 13th Amendment to the US Constitution. Applying specific performance to personal service contracts would be ineffective in giving the promisee what was bargained for. Allow me to say this. Understand the psychological effect of making someone do something in a personal service that they don't want to do. So you've hired a singer to come in and sing. They breach the contract and say they're not going to sing. You wouldn't want a court to order them to sing because here's what you're going to get. Happy birthday to you. Happy birthday to you. Happy birthday, dear. You're making me sing this. Happy birthday to you. You see why specific performance in personal service contracts, you really don't want it. One, it is a form of involuntary servitude, and two, you're forcing the person to do something they don't want to. They'll do it, but you won't be happy, and they'll make sure you know that you made them do it. Let's look at injunctions. Injunctions are available when a breach of contract threatens to produce an irreparable injury. A court can order a party to do certain acts. That's called a mandatory injunction. Or to refrain, to not do certain acts, that's a prohibitory injunction. So for example, an employee with specific skills who has agreed not to work for a competitor may be enjoined from breaching her contract and working for the competitor. Like specific performance, an injunction cannot be used to compel personal service. You can have an injunction that you're not to perform something, but you cannot compel someone to do something they would not want to do anyway. All right, we're at the end of chapter 18. Comments or questions?